Welcome to the Jury Thinks What podcast. Part of the Lawyer Minds ecosystem, the Jury Thinks What podcast discusses everything there is to know about trying cases, from preparing the case before the lawsuit is filed, all the way to trial. And most importantly, how to understand what the jury is thinking. During our journey, we'll be talking to some of the brightest trial lawyers from many walks of life. What makes them successful? What makes them different? Do they have secrets to dealing with the jury? Let's find out. Here's your host of the Jury Thinks What podcast, Saul Gruber.
Thank you, and welcome to this episode of the Jury Thinks What. This is a podcast by trial lawyers for trial lawyers, and pretty pumped about today's guest, an old friend of mine out of the Bronx, Bob Genis. Bob and his late wife have been trying cases for 35 years, and I'm talking about $22 million verdicts, $15 million verdict, $4 million verdict, $3 million verdict, $17 million verdict, and on and on and on. What I love about today's podcast is Bob is real people. You don't see him touting himself, but you're going to hear incredible wisdom coming out of him from what he does right before trial that he calls trial triage. He's going to tell you about some incredible stories about how he uses the defendants as his main expert in virtually every case. It's just some really good stuff. I think you're really going to enjoy it. And stay tuned, because here comes Bob Genis. Okay, so we are here with an old friend of mine, Bob Genis, out of the Bronx in New York. Bob, thanks, first of all, for joining me. How are you doing?
I'm doing great. How about yourself, Saul?
I can't complain. I can, but does anybody care? I don't think they do. Bob, we were talking a little bit before we started this, and I've always joked with you in the past. It seems like every time I turn around, you're picking a jury somewhere in New York, and then you're getting a 7 or 8 figure verdict somewhere in New York. Is that a fair assessment?
I'm on trial a lot, and I do the best I can.
At the best you can. I was looking at your webpage, and I wasn't looking at settlements, which were impressive enough, but I was looking at $8 million verdict, $22 million verdict, $15 million verdict. That's incredibly impressive. You have to realize that, right?
Well, thank you. As I say, I get lucky, and I try to be prepared.
So what I thought would be great, because we try to put out, and as you know, because I know you're a subscriber to our podcast, we try to find different lawyers all over the country that aren't necessarily in the news, but because they're spending too much time picking juries. And I want our listeners, which is a lot of both experienced and inexperienced lawyers, to listen, and we like to talk about trials and how we think and things of that nature. So how long have you been practicing law?
Graduated law school in 83. I passed the bar in 83, but they were slow back then, so we didn't get admitted until 84.
Oh, really?
Within 3 weeks of getting admitted, I'd never done a deposition. I picked my first jury on the med-mal case.
Oh, my God.
The verdict.
Now, how many trials do you think you've had over the last 30 some odd years?
Well, if you say to verdict or just being on trial?
Let's start with the verdict.
The verdict, I'm going to guess somewhere between 100, 150.
And being on trial, probably double that.
Easy, double that. Because, sometimes cases settle after you open or after a few witnesses, you beat up the defendant, whatever.
Exactly. I've always found I still think it's crazy that defense lawyers, probably in your jurisdiction, are talking to the carrier and saying, oh, he's not going to try this case. And it's not until you open that they realize you're trying it, and then they offer the real money. You'd think at some point they'd realize you're actually going to try the case.
That's, look, the defense lawyer has to make a living, and the insurance company wants to show how tough they are. Okay. That's
a great attitude. That's what I love. I've always loved that about you. You don't take really anything personally, do you?
No. It's, even, and sometimes you have a lawyer who gets personal. Okay, we got jerks in the business. It happens. So,
well, that's just a great way to look at things. There's so many younger lawyers out there now, and I see it either on listservs or on different Facebook groups where they're freaking out because a low offer has been made, and they want to know, how can I make them pay me the right number? And of course, my answer to that is always pick a jury.
Right.
That's just there's nothing you can do other than that. Do you agree with that?
I do agree. You can't force them and say, let's work.
Yeah.
Let's get to it.
So you were telling me about how you got involved in trying cases a little bit earlier. And I stopped you. I said, let's do this on the podcast because it's so interesting. Why don't you tell us about that?
In my very first trial, I'm working for, at the time, he was one of the original Inner Circle of Advocates members, and one of the top lawyers in the country. He first guy to get a $10 million verdict in New York State on a med mal case. Anyhow, he had a real thick Brooklyn accent, like a cigar Brooklyn kind of Meet Esposito character. And we're downtown Manhattan in the Woolworth building, and Brooklyn is right over the Brooklyn Bridge, the courthouse.
Right.
So he has the chauffeur take me in the limo, and with him, Bob, the kid, he had an eye that went this way. The doctor did a thing to it, it went the other way. So the kid had strabismus, and the doctor did an overcorrection. Okay. So you're going to watch me settle a case now. All right. Try what case doesn't settle. You're going to try a case now. And that was it. Go pick the jury. I'd never done a deposition. The trial was kind of intuitive to me. Jury selection was not. I didn't have to do what I was doing, who I'm looking for, what to ask, and we had no expert. So yeah, exactly. So what I did then, and that's when I developed my whole style of trying a case, was I subpoenaed the defendant, thought of ways to ask him questions to make it a question of fact for the jury. And that's what I did. I got to the jury. The jury was deliberating for 2 days. I did lose my first trial, but again, I was going against a top defense attorney, and I didn't know what the hell I was doing. And I just started. And my boss said, he was actually very nice. He said, just because the jury said the light was red doesn't mean it wasn't green. And that you kept them out 2 days thinking about it was already, that you didn't get dismissed was already a win.
I think not getting dismissed was a huge win.
Yeah. And I've been trying cases the same way ever since. And every single case, I look at a defendant or any defense witness as a free expert. And I just try every single case that way ever since then.
Tell me how you go about that.
Okay. First, I do it at the deposition as well, because they're not ready for it. They don't see me coming, and they certainly don't at trial either. And you got to remember, into making them an expert, right? We all learn, 101 expert it could be based on your education, your experience, your knowledge, whatever. Okay. So I don't care if it's a premises case, a med mal case, a motor vehicle case. Nice and simple. Mr. Driver, once upon a time, you took a test to get your written learner's permit, right? It was a written test, yeah. And you had to learn the rules of the road, yes. And to learn the rules of the road, you looked at the official New York State, New Jersey, fill in the blank, Department of Motor Vehicles driver's manual. Yes, you view that as authoritative with learning the rules of the road. Yes. So now it's already an authoritative treatise, so you can cross-examine them from it, but keep moving. And you became familiar with the rules of the road, yes. And then you passed it, and then the road test, yes, blah, blah, blah. And would it be fair to say that on the date of this crash, you were familiar with the rules of the road?
Right.
Now, what are they going to say? No? Okay, you've already won if they say no.
Right.
Same concept premises case. You're the superintendent. You're the landlord. Okay, were you familiar with the good and accepted practices of maintaining a building, of running a building? What are they going to say? No? Okay, because if they say they're not familiar, well, no wonder why we're here. You're negligent because you don't know what you're doing.
Right.
So they have to say yes. And now you've got them as an expert. And now set them up on the standards of care of, do we agree it's a good and accepted practice to inspect how many times a day? Like to look.
What do you do when the defense attorney objects and says he or she is here only as a fact witness? I'm not going to let him answer or her answer anything about standards of care.
A few things right off the bat. That I'm sorry, I don't see any court order limiting what I'm allowed to question your witness on. I didn't see anything limiting in any deposition notice. There's no such limits. And in fact, under the law, you're wrong. In New York, certainly the law is crystal clear that I could do this. And I have law ready for it. And I go to trial every single time. I've gotten the objection, but every time I've had the judge rule in my favor, and you make them into your expert in a trial, they're my first witness.
Right.
Because I think once you beat up the defendant, the case is over.
Right.
Because they assume your expert's going to be good for you. I hate actually calling experts unless I have to.
I've always said experts can't win the case; they can only lose your case.
Yeah, I mean, you're doing them more for the appellate division than anything else. Yeah. And so you get them to admit what you want. Case is over. I mean, and you get most of the facts through the defendant, so your client has less to do. And the ideal
Absolutely.
case, all your client has to do is say, I'm hurt, So
It's funny. I've been trying nursing home cases that way for 30 years. We always use, we notice the administrator as an adverse witness, file a motion eliminated, treat them on cross, and set them up. What we've always done, I'm curious what you think about this. I actually, in my head, when I put the administrator on first, I kind of use them twofold. One, to explain to the jury like what a nursing home is, how it's run, and why the regulations are so important. And I do that, believe it or not, almost from a direct point of view.
Yeah.
Then I kind of shift in my head. All right, now I'm going to get into my clients. So I move as we would on cross. I leave my table, go closer to them, and then just start asking more of the leading questions. I almost like shift gears in my head. Do you do anything like that?
It's, I start off, I always start off being nice, and
Sure.
you have to be mean. And then, but as I say, I'm just direct. Like, I just want to set them up. I've got like a 2-minute drill. Within my first 2 minutes of any witness, I've already gotten what I really need to, and everything after that's icing. So right off the bat, within 2 minutes, they're admitting it's their duty to make sure the property is safe, and it's safe for all foreseeable users. Okay. And, whether it's little old ladies, whether it's people that are blind, mentally impaired, physically disabled, it's got to be safe for everybody.
Right.
These are all the foreseeable users. And if it's not safe, you violated those good and accepted practices and procedures. That's right. So, and we get into what's the definition of safe is. And I'll get them to admit that any condition that can cause somebody to trip or slip and fall is an unsafe, dangerous condition by definition. And it's not allowed to exist.
Wow.
And you ask, what's the maximum response time, right? Let's assume you're doing your inspection, and the whole inspection is huge, because the whole thing is you have to identify what a safety hazard is or potential safety hazard. How do you do that? And sometimes the witnesses need help, so I'm there to help. I'm a friendly guy. And
that's why you're there, just to help the witness. I love
I'm
that.
there to help. So I'm here to help. And so then, they'll talk about so what's an unsafe condition? And it's great when they can't even answer the question.
Right.
Let them flounder. And then, well, would a crack be an unsafe? Yeah. Would a chip? Yeah. Would an uneven condition? Yeah. Would, go through all the different possibilities, obviously, including yours. Okay. So if that's there, that's an unsafe condition. Yeah. That's a hazardous condition. Yeah. That violates good and accepted practice and procedures. Yeah. That violates standards of care. Why have one departure when you can have 5 departures? Okay.
Right.
And then after you get that, and so that's never supposed to be there. What's the longest period of time you would ever allow such an unsafe condition to exist? And usually they'll always say immediately. It's got to be fixed immediately.
Right.
So I'm the nice guy, yeah, but sometimes you can't. You can't always get to it immediately. So what's the max response time? Couple days, you tell me, and I'll throw them, 2-3 days. A week. Okay, a week. Because you can have testimony that was there for more than a week or whatever, and the appearance of it, the photos. I'm like, okay, so if it's there for longer than that, again, you violated the standards of care, violated good and accepted practices, blah, blah, blah. Yeah. Now we get to the next thing is, okay, during that interim step, before he gets fixed in that few days to a week, can we agree that there's other things that are supposed to be done according to good and accepted practices? Sometimes you're not sure what I'm getting at. So what do you mean by that? Glad you asked. Warnings, barriers, barricades, things of that nature. Yeah. And why do you do that? Well, to prevent people from walking where it's unsafe and I said, and falling, getting hurt. Right. So it's to prevent unnecessary harm. Yes. Okay. And so that's, again, what's supposed to be done according to standards of care. Yes. Okay. And if you don't do that, you violated it. That's correct. Now is when you take out the picture. Okay. First of all, we agree it shows the safety hazard. Yes. There's a trim defect right there. You can circle it. Yeah. That's the safety hazard. Okay. Do you see any warning devices or barriers there? No. Agree, you already violated the standards of care because there's no warnings, barriers, or barricades.
And at that point, you don't even care what the answer is, right?
Correct.
Yeah.
Okay. It's like, ask all win-win questions. If they, it's like, I was doing a med mal a while ago, it was a couple of years ago, and I'm questioning the doctor on standards of care. I'm getting into, do we agree they exist for the benefit of the patient? Yes. And it's there for safety. Yes. The doctor's job is to guide and, safety and blah, 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 promote safety. Correct. Okay. And do we agree a physician is never allowed to unnecessarily expose a patient to harm? Yes. Okay. And I go, well, what happened was first I go through all these questions and the doctor is disagreeing with me, which I liked even more.
Yeah.
No, it's okay to unnecessarily expose them to harm. It's okay to endanger them. It's okay to, and I'm loving it. And the defense attorney is flipping out. So he said, Bob, do you mind if we take a break? Go ahead. Do you mind if I talk to my client? Go ahead. talks to the doctor, comes back. Would you mind re-asking those questions? Sure. I ask him again. Now this time I get the different answer. So I've got them both ways. It's even better.
Crazy. So you don't even care that he spoke to the lawyer because you have the first set already sworn and under oath. Right.
And then you could put on the record, and you just spoke to your attorney, and you want to change any of your answers after you spoke to your attorney? Yeah. Oh, okay. And
let me ask you a question, Bob. In depositions, do you ever ask the witness what can happen if something's not done through the appropriate standards? What can happen to people? And let them give you all the different things, a full list.
That's correct. And then, as I say, they sometimes need help, so you have to help them with other things. So if the bed rail's not up, what bad things can happen? Okay,
right.
And so
exactly.
They could fall out of bed and break bones like a hip, or they could hit their head and die. They could be brain damaged. They could be quadriplegic. So that's pretty important to have those bed rails up, isn't it?
We used to, or at least I used to, when I was still trying cases, and it's only a couple of years ago, is take their answers from their depositions and make a board out of it. So that when I put them up, I would say, now, if the care plan isn't done correctly, we discussed earlier what types of things can happen. Why don't you tell us what you said? And then I have it there. And I just keep hitting a button every time they say it, and I'm ready for them. So it's right there. And invariably, 8 of those things happen to our resident. But why else would I do it?
Right. It's effective.
It really, I've seen it. I mean, it really is effective.
It's double because the jury's hearing it and they're seeing it, and that printed word,
Yeah, and really, what I find interesting, what you're talking about is you're doing all this first.
Yeah.
Right. You're not putting your client on first. I love that. So you're framing the whole trial just because of who the first witness is.
Yes.
Can you think? I'm gonna put you on the spot.
Go ahead.
Can you think of any reason you wouldn't do it that way?
It's got to be really rare. Because I think, again, you're right. You are framing the case, and the focus should always be the defendant's conduct and your client. You put your client on, it's all about your client, and you could lose. I want to do the defendants. And look, I don't know about you, Saul, but most of the clients I've had, most are not great witnesses. You got a handful of really good ones. So you kind of want to bury them in the middle,
Yeah, sure.
The liability from the defendant, sometimes even damages from the defendant, depending on the kind of case it is, and your client in the middle. And then all the other witnesses, the doctors at the end to talk damages. Sometimes, depending on the case, I might have the doctors before my client and the lay witnesses before my client to really set the stage.
Yeah, I've always proved damages just because I've always done either med mal or nursing home. And for me, all the damages, the people who have the most knowledge are the defendants and their employees. Okay. So I've always used, like if we would have 10 witnesses in a trial, like taking out our experts, only one of them is my client, right? The 8 are done because I served with a subpoena to appear at trial. Yep. I love that. I like to bury, quite frankly, my clients in the middle somewhere.
Yep. Absolutely.
And just get them on and off as quickly as possible.
That to me, only a client can ruin a perfect case. You can have that client who's a passenger in the backseat of a hit in the rear, and they can screw up that case.
Oh yeah, well, because our clients are our clients. They're real people. They're not made for courtroom, so to speak. And half the time they're so scared.
So they're terrified.
And why shouldn't they be? At their deposition, the defense attorneys normally mean bringing up, isn't it true you lied in high school once, and meanwhile they're 50 now. It just like crazy stuff.
Yep.
Interesting. You also said something which I think is fascinating. Is after 2 minutes you've got what you need. Tell me more about that.
Because look, first impressions are lasting impressions, and you want to hit the ground running. It's like even on opening. I was teaching a class a week or two ago on advanced trial practice, and I disagreed with all the other lawyers on the panel. All the rest of the lawyers on the panel, they thank the judge, they thank the jury. It's a roadmap. I'm like, oh my God, I'm falling asleep already.
They actually said that?
Yes.
Wow.
And I said I'm falling asleep, but and I said no. I said, first of all, if by the end of voir dire, if they don't know who you are and who your client is, you got bigger problems. Okay?
Amen to that. Amen to that.
Right?
Yes.
And also, have you ever had a trial where the judge didn't introduce you to the jury and who you represent? They heard it. They get it. What do you they're on the edge of their seats when you're about to open. It's showtime. You want to hit the ground running. So boom, I'm right to it. I'm out of that intro. No, boom, get right to it.
Right. And you know, let me ask you this question. I mean, we've over this last year, we've all been watching a lot more television than we've ever had before, right? Did you ever start a movie and the first 5 minutes are meaningless and stay with the movie?
Yeah, exactly.
No, it's on Netflix. What's the next movie? Because that was boring. Right. I never understood the introduction.
No, it's just get to the point, hit the ground running, keep them while they're hot, while they're on the hook, get them.
Well, don't you really need to get them in that first 45 seconds, I think.
Yeah.
In order to keep them, and then just layer it after. At least that's what I do, and that's what I teach my clients to do. Right. Is if I can still remember something I learned in law school, and I did it once, and I got in so much trouble from the mentor lawyer. In my opening statement, I did what you said. Your Honor, may it please the court. My name is blanket. Well, my name is Saul Gruber, and I have the honor of representing, Stand Up. All that's bullshit. And then I said the roadmap, and I said, and what you're going to hear from this witness stand, and what you're going to hear from lawyers is not, what you're going to hear from me is not evidence. Evidence only comes from documents you're given and what you hear out of this week. So now I'm done my opening, and it was a nothing case. And my boss looked at me and goes, Did you just tell them what you hear from me is not evidence?
Right.
He said, maybe you shouldn't be trying cases.
Yeah. I'd say, why would you tell the jury, don't listen to a word I say? I don't know what I'm talking about. I don't count.
I still, 33 years later, I still laugh at that. And I think to myself, oh, what an idiot. It's absolutely true. I mean, I'm a big believer of getting as much information as I can, right? So I read all the books.
Yep.
I know all the consultants, right? As do you. We brought them in. We've tried cases with them, whether it's Rodney Jew, whether it's David Ball. I was part of the Keenan Institute for Nursing Home cases. All of them say the same thing, though. You've got to frame every word that comes out of your mouth. There has to be a reason for.
Yep.
And especially in an opening statement, it's got to frame the case, and it's got to suck them in. And if you're not doing that, you're not doing your job.
Correct. I agree. And it's look, I taught at the Masters in Atlanta. I know Don, I know David, and taught with both of them. And it's, look, set up your rule. Set up the rule, and the rule's only there, only when jurors like you enforce these safety rules to protect us.
Exactly right. Then you empower the jury to go say, you know what, you're right, Mr. Genis. We're gonna do what we can do to stop this from happening again. Right. I mean, it's not rocket science.
Give you an example on a dental mal I did about a year or 2 years ago because of the pandemic. Where and this was the frame. I started out, with the statistic of, every year, over 400,000 people die unnecessarily due to, medical malpractice, blah, 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 because the violation of safety rules, like I said, what keeps us safe is you. Then when I finally start talking, now I'm 15, 30 seconds in max at this point. So now I start talking. In Queens, there is a clinic. In this clinic, they have dentists. They hire the dentist right out of dental school. They give them no training. They give them no supervision. They give them no monitoring, and they pay them $400 a week. Now, right off the bat, no juror thinks a doctor should only earn $400 a week.
Right.
Okay. And I said, but if they do extra work on the patients, they make commissions. They make more money. Now, if you're a juror, you already know there's malpractice before you heard what this case is about.
Right.
Because it's a clinic, it's a mill, they have inexperienced people, they're leaving them alone, and they know the more work they do, the more money they make. This case is already over. And if I would have started talking about the malpractice is, that he, when extracting a tooth, he fractured the guy's jaw, well, maybe not, it could happen, okay. But when you frame it that way, before you got to malpractice, they already know they're guilty.
Right.
And when you get to it, of course they did it wrong. It's just, that's the frame.
That's and you make it sound so easy to come up with the frame. I mean, do you ever struggle with coming up with the frame in your case?
Well, sometimes some cases require more thought than others. And then look, I'm about to try a case in federal court. Literally, we're doing our requested charge now because federal court, they front load everything. So
and we can agree there's nothing more fun than the joint pretrial before. Nothing is more enjoyable than that form.
I did that, the motions in limine, and I just opposed the cross motions in limine. And then I had to oppose the motion when they, Friday afternoon at 4 p.m., served the surveillance videos on me. So I had to, by Monday morning, submit my op to that. Yeah, I'm having a blast.
Ugh.
But one of the things you have to think strategy-wise sometimes, like on this particular case, I'm trying it for another lawyer. They made perhaps an error. They did not sue who perhaps could have been sued.
Right.
I'm not going to say more about it than that.
You don't have to. We've all been there.
Yes. Okay. So the bottom line is it's a trucking case with a twist. You have Walmart. Walmart has all of these cardboard products, from the boxes they get the packaging. They
Right.
compact it, they smash it up, they tie it into bales. Each bale weighs about 900 pounds. They fill up a trailer. When the trailer is filled, they ship it to the recycling center. Walmart makes money for the recycling center for recycling it all, and that's fine. So what happens is they send it to the recycling center. They leave the trailer there overnight. My guy is a schlepper, okay? What he does is he sweeps, he cleans. They wanted to back up a trailer and open up the back swing doors so that they can now unload, the cardboard. Great, that's what he'll do. So he does this. He opens up first swing door and he sees what he always sees, that the cardboard is to the roof, doesn't think anything of it. Opens up the other swing door, same thing, except now all of it falls on him.
Right.
Thousands of pounds of cardboard. He's badly injured. Now, there is a federal Motor Carrier Safety Act regulation that puts the onus on the driver of the tractor trailer to make sure it's safe. Now, the driver and the driver's company is not a party to my lawsuit. Walmart is the defendant. They're pointing the finger at them, saying they're 100% at fault, 100%, period, end of story. So I actually got brought in by a fluke. My friend asked me, can you do me a favor and do a deposition or two for me? Okay. I saw that they had no liability against the 10 depositions they did were all worthless. I did one Walmart guy. I got him to be my expert and him to say, it's irrelevant about the driver. We're supposed to make sure it's safe. Well, the driver shouldn't rely, blah, blah, blah. So I got him what I needed, okay? So he's my first witness at this trial, obviously. But now one of the issues is in New York State, we have certain weird laws. Every state has weirdness. Is we have what's called Article 16. Article 16 of the CPLR is a limitation on liability. You already have this in Jersey, where if you don't get over 50%, you got a problem.
Yeah.
Okay. In New York, normally, if you don't get 50%, they're only responsible for the pro rata share.
Right. You're talking about joint tort fees or liability. Right.
Yes, I am. I'm sorry. I should have said that.
No, that's why I'm here.
I knew there was a reason.
That's why I'm here.
Yes, joint tort fees liability. Yes, I should have kind of mentioned that because people don't know what the hell I'm talking about right now. So anyhow, so in New York, though, if it is a motor vehicle case, then the limitations do not apply. So all you need is 1% in for a penny, in for a pound.
Oh, wow.
Yeah. So I did a law motion in limine that under New York state law, a trailer is a motor vehicle. And unloading a trailer is considered use and operation of a vehicle. So I said under Article 16, there is no limitation. All I need is 1%. So let's assume the judge says I'm right, and I think the judge will, because I think I am right, okay? So now I'm not really going to tell the jury what your normal instinct might be. It's not the driver's fault at all. It's all Walmart.
Right. You don't care because you just need 1%.
I'm just going to say two wrongs don't make a right.
Right.
Okay? And, and look, whatever the driver's responsible for, they are. But, what are you going to give Walmart a pass on safety?
Right.
And that's going to be my approach.
Yeah, almost like this was that if either of them did their job, this wouldn't have happened.
Right. They didn't do their job because they passed the buck. They figured the driver will do it.
Right.
And I'm thinking, like, who should be held accountable? The shipper or the schlepper? And, and
interesting.
I'm going to try the case.
I can talk about this type of strategy all day. I mean, that's what I do for a living now. I just think it's so much fun. It is. To just, what about this? What about that? And I think when I listen, and I watch a lot of trials, we've got 50 cases all over the country, and I start listening to people. I look at their outlines for trial, and I just scratch my head. I'm like, no. Why? Who cares?
Right.
I want to talk to you a little bit more about that. Sure. Because I find that the cases that are quicker tried get better verdicts. And the cases that take weeks and weeks, I never understood what takes a plaintiff lawyer 2.5 weeks to prove their case.
Although I'll take the converse of that. I agree with you on the quicker trial, but I have a friend of mine in New York, terrific attorney. He loves long trials. He trials cases for 5 months, 7 months. Okay. I blow my brains out personally.
Yeah.
But he gets phenomenal results. 45 million, 55 million.
Wow.
He gets great results. And I think part of his philosophy is if the jury is there that long, they are vested. Was their time worthless?
Yeah. Well, they're definitely vested.
It's a big case.
But are they pissed? That's what I would be worried about.
Well, put it this way. Every jury, whether it's short or long, is going to be pissed at somebody. As long as it ain't you, you're fine.
Well, and that's the other reason I've told people, be as brief as you can, because the defense attorney's never brief.
Yeah.
So if I put a witness up and it's 20 minutes and they're an hour, I put my second witness up and they're 30 minutes and on cross it's 2 hours, they're not going to be pissed at me. They're definitely going to be pissed at the defense attorney, and they're going to stop listening to the defense attorney by the third witness.
Depends.
Well, yeah.
If in terms of time, I do long crosses, okay? But I think the issue is, are you being effective?
Right.
If you're taking 3 hours, but every punch you're hitting is hard, if you're effective, it's fine.
Right.
The jury won't mind if you're long. Okay. I've had witnesses I've crossed on for days. Jury didn't mind because I was just flogging them for days.
Right.
On the other hand, if you're not making points, 5 minutes is too long. So it's if you could do it quickly, I think that's the better way to do it. But sometimes you do it long. So every case is different, every witness is different. And I think as long as you're proving points, they don't mind. If you're not proving points, they're going to be pissed at you.
So you're getting ready for trial, and you're taking some direct. How do you figure out how many points you really want to deal with each witness and in your case?
Well, you have to think out what's the goal of each witness. What are you trying to accomplish with each witness? You don't have to prove things more than once necessarily, unless it's something you feel needs corroboration.
Right.
But that's it. But if it's already been proven, why do it again and risk getting a bad answer and screwing up your case? So what do you want to accomplish with each witness?
I used to, and I still do. I mean, some people use the phrase storyboard. I don't. I just use the phrase. I write it down on a legal pad. I kind of have my witnesses. Yeah. And what are the points I want from each witness?
Right.
Who is the best to give me those points? Yep. And then I find I cross half the witnesses off. Well, I don't need them.
Exactly.
Okay.
I agree with you. And the only other thing that I find, if I'm doing this for a while, so as are you, sometimes the witnesses you think are going to be great are awful and vice versa.
Oh, there's no question about that.
Yes.
Yes. There's absolutely no question about that. But that's kind of why although my witness list may have 12 people on it, and I only really want to call 4. I keep the rest on the list just in case.
Yeah.
Just in case one of them tanks. I'm like, all right, we bring something else in. Tell me about how you prepare your witnesses. How do you go about preparing them?
Okay. It's first, you got to learn how your client thinks and speaks, so to speak. Because I see too many times lawyers try to put their words and their thought process into the witness, and they don't think that way, and they don't talk that way. And
right.
And it's too hard for them because now they think they have to memorize your words, and now they get stressed out when they forget your words, and then they really start screwing up because they're completely stressed, and it's a nightmare. It's a train wreck. So how do they think? How do they talk so that you can get them to say what needs to be said, but using their mouth, but just helping them make it a little bit better.
I used to, and it was horrible for the first 10 years of my career. So we're going back to the early 90s, late 80s, early 90s. I would give my witnesses my outline of questions so they would know what I was asking them. I thought it was smart. It was by far the dumbest thing I ever did. Because now they're like, oh, you asked that out of order.
Right.
You didn't go in the order you gave me, and you left out these 3 questions, and they're panicked. Yes. And I'm like, nah, no more. Now it's just tell me how you feel and just talk about that.
Just, so it's you got to get to know them, know how they think, how they talk, so that you could, it's like the old Jewish joke. There's this guy in court in Brooklyn. He's on trial. And the witness is a religious Jewish guy. Now, I don't know if all you people get this or not, but whatever. So he's a chassid. I don't know if they even know in Iowa what a chassid is, but anyway.
I do.
Okay. So the witness understands, and the lawyer questions him, how old are you? Baruch Hashem, I'm 81. Answer the question. How old are you? Baruch Hashem Amedi. Judge, admonish the witness. He's not answering the question. Mr. So-and-so, Mr. Schwartz, just answer the question. How old are you? Baruch Hashem Amedi. And they're getting all pissed off, madder and madder. So finally, his lawyer says, do you mind if I ask, Judge? Go ahead, Mr. Jones. Okay, lawyer takes over. Baruch Hashem, how old are you? Okay, 81. You got it. Okay, how do they think? How do they talk so that you can use their words that come natural to them?
That's funny, but it's true. It's definitely true. There's so much I want to talk to you about. It's funny because now that I'm down here in Miami, although everybody says there's a lot of New Yorkers and New Jerseyans down here, not like you. It's so nice hearing somebody speak quicker than me. It's been a pleasure. I've been spending a lot of time in Atlanta, spending a lot of time in Kansas City. We're not out there. I love the way you speak. So now you're a month.
Apropos of that, I'm teaching a CLE up in Buffalo one time, and somebody asked a question, and it was about a tactic some defense lawyers, I don't even remember what it was, but it was such a stupid tactic, And I said, when you have a lawyer dumb enough to do something like that, and is that stupid, you pray for the health they shouldn't catch a cold. Okay? And I'll go a step further, so you'll appreciate. I'm on trial, upstate New York, in a federal court case, police case, and the judge at one point admonishes me because I talk with my hands and my inflections and all this kind of thing, and and he doesn't. And upstate they don't do that. And right. I just looked at him in front of the judge. I said, Judge, I'm a Jew from New York. This is how I talk.
Yeah.
Okay? And they don't know what to do with that. Okay.
Yeah, well, that's exactly right. Yeah, that happened to me in Kentucky once. So I get it. Yeah, I definitely get it.
Yeah.
One of the things I think is incredibly important, you're trying the case, but the only way you can frame it the way you're talking about, plan to use defense witnesses as quote unquote your expert, is if you think about it beforehand.
Absolutely.
So those 3 months or so before trial, what do you do? How do you figure all this out? What you want to do, when you want to do it, things of that nature?
Okay, every case as what I call trial triage, and a lot of my cases, about 70% of my practice comes from other lawyers. I prefer when I get the case early on, but sometimes it's just for trial.
Right.
So you got to go through the file, and right off the bat, my triage, because we do things a little different in New York than New Jersey, is we have a subpoenaed record room in every courthouse, and they look down upon lawyers bringing their own records. The philosophy is we don't trust lawyers. So records go to the subpoenaed record room where they're safe, supposedly, okay? So anyhow, first thing is, have the subpoenas gone out?
Right.
So we have all of our records, whether it's medical records, accident reports, whatever you want, in the subpoena record room. Because if they're not there, you have judges not coming into evidence. They don't care if it's certified, they don't care, whatever. Got to be from the subpoena record room. So that, okay, are your witnesses around? Are your clients around? For example, and I've had, depending on your practice, you can't get hold of your client. Well, did you check the website to see if he's in jail? Because what if he's incarcerated? It could happen. What if he's dead? What if he's whatever? So is your client around? Are your witnesses around? Are your doctors around? So, right off the bat, can you do that stuff? Okay. So let's assume the subpoena's around, you have your records, and everybody is still alive and well and accessible for trial. Okay. So now then I start to thinking of my demonstratives. I'm very into demonstrative evidence. So, I like posters. I know a lot of lawyers, they're very into the technology and the power, I know. I am an idiot technologically. And plus, to me, there's nothing worse, and I've seen it in CLEs, I've seen it at trial, when the lawyer, the computer is just having a little glitch, I can't find, it's horrible.
It's funny you say that.
It's an eternity.
I could still remember an opening statement where I go like this and the screen is blue.
Right.
And you're like, let me just do it. But it's horrible.
Horrible.
I do like technology because most of the cases that I've tried have a ton of document evidence. I mean, that's what a nursing home case is. Look at this. Here's the care plan. We tried them, I guess, in the last 10 years with our iPads. And I would have everything pre-marked, put in the iPads, it could be brought up at any point, and then had a backup iPad with everything on it just in case. Still, we would have witness books. So every piece of evidence I was going to use with any witness would be up in the order I think I'm going to use it in.
Okay.
And then I would have witness books. So every piece of evidence I was going to use with any witness would be up in the order I think I'm going to use it in. Okay. on the witness stand. So even if something zaps out, they have it. And anything really big, you're right, you got to have a poster board with it too.
Yeah.
If it's that, and yeah, 2 or 3 documents in every case probably that you just have to have.
You know, especially on the damages. By the way, like everything you're saying, it's great. It's very labor intensive, you know, what you're talking about. It's
yeah, it is.
But I like the poster, especially for the damages, because by the way, a poster they could take into the jury room and look at, and my, PowerPoint, they cannot.
That is absolutely. That's why I know a lot of people, rather than have things pre-made when they're doing the big cross-examination, they'll use an easel and paper and write, because the jury can take that back.
Right.
The witness can initial it. So you said damages. What kind of things do you put on poster board for damages?
Okay. So for example, I'm making posters right now for this trial. Okay, what's your case? For example, is the dispute another trial I did a while ago? It's a motor vehicle case, neck injury. The defense was causation. You didn't diagnose it for a number of months until whatever. But look at that ER chart. And what's the smoking gun in the ER chart? The cervical X-ray shows loss of lordotic curvature, straightening, flattening, whatever word you wanted to use. Okay, so what I did was, to me, a key thing for the demonstratives was poster number 1. It has a X-ray of what a normal neck looks like, where you see the curvature. And then my client's X-ray from the emergency room, and they do like a red line kind of through it to show, here's how it should have curved and see how straight it is.
Right.
Right off the bat, you see the day it happened, an objective injury to the neck.
Interestingly, all the focus groups I'm doing want that. They want to see the normal.
Yeah.
They want that so much more than anything fancy. They want to see normal versus what this person has.
Right. Okay. And then I'll also maybe even blow up next to it, or even have like as an insert in that poster from the ER chart or from the radiology report, loss of lordotic curvature. So it's not just us saying it. This is what they said at the time.
Right.
And that's there and then that day. Okay. That's an important piece of evidence for causation. Let's say you have the spinal surgery. Don't you want, your poster boards to show what's involved in the surgery, and using actual X-rays or MRIs to show the hardware, to show this is his neck,
So you use a company that does the medical illustrations for you, the surgical boards?
Yeah, I do. It's actually a Jersey company, certified medical illustrators.
I know them well. They did all my animations for 30 years of how a pressure ulcer happens and things of that. Peter, they're good people down there.
Yes, exactly. So, and they do a lot of my work, and they do a beautiful job. And I think that's, I evolved years ago. I used to do like a big poster of the operative report, the words. And then I said, okay, let me do the words and the image.
Right.
I realized get rid of the words.
Yeah.
Because they're busy reading it instead of listening to the witness. They don't know what the words mean. And who cares what the words are? The picture tells the story.
Well, that's the whole point of it, right? I mean, if the picture doesn't tell the story, it's a bad board.
Right. So I don't even do blow-ups of the operative reports anymore like I used to, because it's distracting.
Yeah. And really for that, you can use your computer for that. Or you put it on an Elmo. I mean, it's the same thing. What I loved about certified medical illustrators, and I think anybody listening to this has to have their own illustrator that's near them. I was in federal court. It was a disc case, and they had these great boards with the spine, and they made the disc red, like leaking out. Right. Objection. I couldn't believe there was an objection on it, and the judge said, "Well, is it red that leaks out?" I'm like, I don't think so, Judge. Because then I'm not going to let it in, because it's so now. Luckily, I was in federal court in Trenton, which is around the corner from their office. Within 2 hours, I had a new board. This time it was gray.
Okay.
And she allowed it in. But I think that's an important thing to remember for anybody who uses medical illustrations.
Right.
Use somebody who can replace that if there's an issue that day or the next day, or make sure early enough there's not an issue.
Well, it's funny. I had a similar type thing happen once, but it was words that were on the board, and the judge didn't like the words. So what we did was we just got a piece of paper clipped it on top or stapled it on top so they could see it. But it just kind of highlighted it even more.
It really does. Yeah, it really does. That's too funny. So you're doing your triage. You're like, all right, are the records available? So for everybody else who doesn't have a subpoena room, which I think is really just New York, do we have all the records we need? Are they in a form that we could use at trial? Are they in a form that our experts need? Are our witnesses available? Are our experts available?
Right.
What's next in the
Okay.
Bob Genis world?
Okay. Look, if I had the luxury of time, I mean, I normally don't have time. I go back
Right.
to back to back and, whatever. So, okay, the subpoenas are out, the demonstratives are there, law memos. What are my issues going to be? What are my problems in evidence? Because there's always problems with evidence that
Yeah.
either things I want to keep out or I want in. So, okay, do I have my law memos ready? Now, in federal court, I got to do my motion limiting well in advance. In state court, we're trial by ambush in New York, so it's on the spot. I'm handing the law memos. But when I'm on trial, I'll have anywhere from 10 to 30 law memos already ready to go on any possible topic. As soon as it comes up, here you go, Judge.
That's what we used to do. We called it our trial back.
Okay.
I mean, there's always going to be a hearsay issue, right? There's always going to be a statement and a record. At least my experience has been, especially when they're warrant malpractice cases, they were premises. I wouldn't say regular personal injury cases. There's always a statement in some medical record that may or may not be attributed to your client that either you want to get in or you want to keep out.
Yep.
Depending on which side of the ball you are, was the memo I had.
I have an appeal on that issue because I had a trip and fall case in Manhattan I tried, and there were 6 different entries in the hospital chart about 6 different locations and manner in which you felt. Okay, I kept them all out because I had my law memo ready, and they brought in outside the presence of the jury 2 doctors and 2 nurses to testify. But when the bottom line with the New York law is, who is the actual declarant? And if it's not the patient, you got a hearsay problem.
Right.
So you can have this if it's a child, or in this particular case, English was not his language. So he spoke through an interpreter. And so you're not writing down what my client said, you're writing down what the interpreter said.
Right.
And in New York, if you don't bring in that interpreter to say, yep, that's exactly what he said to me, it ain't coming in. So I kept it all out. And that's an issue. Post-trial motion, they moved, denied. They're taking an appeal. I feel pretty comfortable on the appeal on that.
I was in trial in Newark. Similar thing. It was what we referenced earlier. My client fell out of a bed in a nursing home, rushed to the hospital where he has surgery. At the hospital, the doctor writes, resident said he was walking to the bathroom, not he fell out of bed. I'm like, oh boy. So we block it. The lawyer gets the surgeon. So it's 7 a.m., right? Because when else would you do it? We're taking the deposition for trial of the surgeon, where he says, "Yeah, that's what he said. Do you remember?" No, but it ended up coming in, and it hurt. But that sometimes really makes or breaks your case. Those little things.
Yes.
I don't know if you know Brian Brown in Baltimore. Brian, I had on the podcast. He was last year's Maryland Trial Lawyer of the Year. I try to have important people like him and you on the podcast. And he said what he tells everybody to do in his office. He's got about 20 trial lawyers in their office. He tells everybody to have a cheat sheet for everything you want to move into evidence and any objection that there possibly could be, just so you're ready for it.
Okay.
With like a little memo. I don't know if you probably don't need the cheat sheet, and I don't think I do either.
Yeah,
but,
I mean, but for a younger lawyer, I think that's a good idea. Or a less experienced lawyer, that's a good idea. So you have it, and it's easy. You and I, I don't need the cheat sheets, but if there's an issue, I already have my memo, and I'm ready on it.
And what we did, I don't know if you guys in New York have those softback books that people put out, but in New Jersey, even down here in Florida, like Abbott Brown and John Lemura wrote the Meg Mal book. If somebody, I would always get that in Word. Okay. And I would have my paralegal make sure that we if there was ever an issue, we had that in a memo form, straight out of the book. We'll even reference the book in words with our arguments that will be given to the judge. Same thing with evidence. It's just ready. I think that's important.
I think it's key. And first of all, it shows the judge you're prepared, which, by the way, the other part of the triage and showing the judge you're prepared is, let's put federal court aside where they require you to do all this stuff.
Right.
In state court, when I walk in and I see the judge for the first time, here's my proposed requested charge, proposed verdict sheet. And if there's any key issues, here's my law memos. So the judge sees the first time he or she meets me, I'm prepared, I'm ready to work.
Right.
It sets the tone so that you now have credibility with this judge on other issues even.
I think that's brilliant. And we did the same thing to the point where everybody would get a loose leaf, binder. Maybe it's 100 pages long, bait stamped, so that if an issue comes up, I would have the judge turn and say, well, let's turn to Mr. Gruber's pretrial page 87. Isn't that the real issue here? And I just wanted I wanted everybody to say, oh, okay, yeah, Gruber did that, or Genis did that, not the defense attorney. And that makes a world of difference when you're arguing motions.
Well, apropos of that, something I love to do, I out of my own paranoia, I do it, but I saw there was another side effect to it. I always keep an extra pad. I'm like, legal pads like you, Saul.
Right.
One of my pads is just to keep track of evidence and what's, plaintiff, defendant, ID, or in evidence. And I keep track of everything. And a lot of courts don't. All right. Exactly.
Each one of these legal pads, by the way, has a different point, has a different thing that I'm doing with it.
Of course.
Yep.
Of course. So what happens is I've been on trial, and now you're putting something into evidence. And the judge, will go to the clerk, we're a reporter, what number are we up to? And I'll say 29, plaintiff's 29, Your Honor. The reporter, a few minutes later, 29, Judge. Or the clerk, yeah, it's 29. And after a while, the judge just starts asking me.
Right.
Mr. Genis, what number are we up to? And when you are the official repository and the jury sees you are the one everybody looks to.
Yep.
It just really carries a lot of weight with the jury.
So absolutely. So we've got our.
And by the way, always make friends with the clerk of the court officer.
You've seen my posts on I don't know how you don't make friends with the officer. I mean, they're just going to, I'm going to say the word, if you're an ass, the judge knows you're an ass to them. I can tell you right now.
Not only the judge, the jury will know.
Absolutely.
What do you think is walking them to and from the jury room?
Yeah, that's true.
And you're questioning or making a comment or an objection, whatever. Do you really want that court officer rolling their eyes every time you get up?
Yeah, exactly right. And not only that, I mean, like you, I was in a lot of new courtrooms because I'd be called in at the last second to try something. I want to know, hey, look, does this judge have a weird quirk with selecting a jury? I mean, I know, do they want you to stand and tap dance? Do they want, what do do I use their name? Do I say juror number? What do I do?
That's, it's funny. There was a judge in Queens years ago, and he had quirks, as you say. Now, I knew about it, but being on trial, the other lawyer didn't. For example, that particular judge, I don't care what the weather was, you did not walk in his courtroom wearing your overcoat. Okay? I don't care if it's pouring out, freezing winter.
That is a quirk.
You took off your coat before you entered the courtroom. Okay? That's a quirk. Another quirk of his, how there's always the rail,
sure.
Okay? Never lean against the rail. Now, we all do, but this judge did not like that, okay? But the last quirk was key that I knew about, okay? And this is something, let's see if you can figure out what's going on here. Okay, the defense attorney is about to start questioning the witness. Now, what's the normal thing most lawyers do before they're questioning the witness? They're sitting there looking through their notes, they're organizing their papers, blah, blah, blah.
Sure.
Defense attorney is doing exactly that. The judge, and I'm just sitting there like this, rapt attention at the table.
Oh, God.
Because I know what's happening. The judge then says, stop. And we all stop. And he goes to the defense attorney, do you realize what's happening right now? And the lawyer's like, no, I don't have a clue what's happening right now, Judge. And he's like, the most important thing in the entire trial is taking place right now. And the lawyer's like, what the fuck is, pardon my language, what is,
Didn't stand up for the jury, huh?
Okay. Because he said a witness is taking the oath.
Ooh.
You have so little regard for the truth, for a person's oath to tell the truth. Okay, you have that little regard. I mean, roasted this lawyer, excoriated him for not caring about the truth when the witness is being sworn in to take their oath.
Oh, geez, you really need to know. Oh, my God.
All right.
I would have just got up and left.
Okay, not knowing that quirk.
Yeah, that's a quirk you need to know.
Yes. Okay.
Oh, my Lord.
Judges don't call your client by their first name. You can't call them Bill or Joe, call them Mr. So-and-so. Every judge's got their quirks. You
need to know them. You definitely need to know them. Yeah. Because if you get excoriated like that by a judge in front of the jury, it's done. It's over.
Right. Right.
Just get up, say, thank you, Your Honor. We'll pay whatever you feel is right. We'll see you later.
Yeah. So learning the judge's quirks are key. As I said, making friends with the officer, the court clerk, really help.
So Bob, this was great. An hour almost went by already.
Like blink of an eye with you, Saul.
Yeah, I would love to do this again because there's so much more I want to hear from you about evidence. But another day.
You got it.
Thank you. Enjoy the weather.
You too.
And I will give you a call when I'm up in New York.
You got it. Come to the beach.
You got it. Take care.
Be
well.
Yeah, you too.
Wow, that was really great. Like I told you, Bob is just a great guy and a phenomenal trial lawyer. And you've been listening to The Jury Thinks What? I am your host, Saul Gruber from Gruber Trial Consulting. And again, a big shout out and thank you to Bob Genis from New York for some real pearls of wisdom, from trial triage to getting in quick to using the defendants as your expert. Just one phenomenal point after another. I think no matter what a skill level you are, you'll learn something today. Again, this is Saul Gruber, and you're listening to The Jury Thinks What on the Lawyer Minds ecosystem. I want to thank everybody for listening and look forward to seeing you again real soon.
That concludes another episode of The Jury Thinks What podcast, part of the Lawyer Minds ecosystem. Thank you for listening, and we truly hope it was worth your time. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content that Lawyer Minds has to offer, and engage with us on social media. Your feedback and ideas are always welcomed. See you next time.